This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about insurance fraud and how an insurer must be proactive in the efforts to defeat insurance fraud, and that when they are successful. Cigna, for instance, obtained a judgment in the amount of $14,371,384.95 against a fraudulent health care provider that was never even bothered by prosecutors or police. And since police, prosecutors, and state insurance fraud investigators are seldom willing to arrest or prosecute insurance fraud perpetrators, it is necessary for insurers to be proactive and sue those who attempt or succeed in defrauding insurers. In Connecticut General Life Insurance Company and Cigna Health and Life Insurance Company versus Mike Ogbebor and Stafford Renal, LLC, a September 6, 2022 decision of the United States District Court for the District of Connecticut, Cigna successfully sued a fake provider and obtained a default judgment for almost $15 million against the corporate defendant and its alter ego individual. Stafford Renal, LLC, and its owner, Mike Ogbebor, received insurance payments from Cigna for dialysis Stafford claims to have administered to two Cigna plan members. Cigna alleged that Stafford was not licensed to provide, and in fact, did not provide these dialysis treatments. After Cigna filed its complaint, Ogbebor submitted an answer on behalf of both defendants. The trial judge struck this answer with respect to Stafford because Ogbebor, as a non-lawyer, could not represent in court a limited liability company such as Stafford. Cigna then moved for a default entry against Stafford, which was granted based on Stafford's failure to appear or respond. As for Ogbebor, he has failed to object or respond in any way to Cigna's discovery request. Ogbebor also failed to respond to a motion to compel discovery despite the court's discovery order warning him that such failure might result in sanctions, including default judgment. Cigna moved for default judgment against both Stafford and Ogbebor. Because Stafford has altogether failed to respond, and Ogbebor has responded but willfully failed to comply with his discovery obligations, the trial court accepted the allegations in Cigna's complaint as true with respect to both defendants, and on those facts, Stafford and Ogbebor are liable to Cigna for submitting fabricated claims on behalf of an unlicensed provider. Ogbebor formed Stafford as a limited liability company organized under Texas law and served as its owner, principal, and manager. Stafford held itself out as a treatment facility for end-stage renal disorder, ESRD, but Stafford did not have an ESRD license. In fact, Ogbebor was associated with another company known as Stafford Dialysis Renal, Inc., which operated a licensed ESRD facility. That license, however, expired in November of 2016. In 2017, Ogbebor submitted bills to Cigna for ESRD treatments purportedly provided by Stafford. Cigna learned that Stafford did not have an ESRD license. Stafford was therefore operating in violation of Texas licensing requirements. Despite its unlicensed status, Stafford submitted and received claims totaling $4,790,461.65 from Cigna for supposed ESRD services to 2 Cigna members. When Cigna asked Stafford and Ogbebor to show proof of proper licensing, they failed to do so. Cigna then reduced or denied payment on other claims submitted by Stafford. The defendants also allegedly fabricated a majority of the treatments for which they sought and obtained reimbursement from Cigna. Further, although Stafford supposedly provided services to one plan member on nearly every day from April of 2018 through June of 2020, Cigna learned from the member and confirmed with Medicare that she did not begin treatment until January of 2019. Now, the court noted that when a defendant defaults, it thereby admits all well-pleaded factual allegations contained in the complaint. The trial court found that the default judgment is the appropriate sanction in this case, and that any lesser sanction would be futile in light of Ogbebor's willful and total refusal to cooperate with this litigation since he was first served in February 2022 with discovery requests concerning information in his possession that is essential for the resolution of Cigna's claims against him. Cigna sought a declaratory judgment against Stafford, stating it has no obligation to honor any claims submitted by Stafford for ESRD services because Stafford was not licensed to provide any of the claimed ESRD services it submitted to Cigna. It has no legal or contractual right to reimbursement payment or other consideration from Cigna. The complaint alleged that the defendants falsely represented to Cigna that Stafford was licensed to provide ESRD treatments when it submitted claims seeking reimbursement for those services. And when submitting these claims, the defendants knew that Stafford lacked the requisite license and that most of the claims were fabricated. Since Cigna's claim for fraudulent misrepresentation is adequately alleged to support a default judgment, its claim was granted. The trial court also concluded Cigna's allegations are adequate to support a default judgment for negligent misrepresentation, and under the Connecticut Unfair Trade Practices Act, entitled to recover actual and treble damages. The Connecticut Health Insurance Fraud Act punishes intentional fraud or deceit in connection with a claim for benefits under a health insurance policy, and an insurer aggrieved as a result of an act of insurance fraud has a private right of action against the perpetrator of such fraud to recover all damages resulting, and therefore Cigna's allegations were found to be enough to support a default judgment. Similarly, civil theft is recoverable in Connecticut, and Cigna, who issued payments on fraudulent claims, were entitled to recover damages for civil theft. In addition, Cigna asked the court to pierce the corporate veil, and it did so because under Texas law, holding an individual owner or manager of a company liable for acts of the company is appropriate, one, where a corporation is organized and operated as a mere tool or business conduit of another, and two, there is such unity between the corporation and the individual that the separativeness of the corporation ceased and holding only the corporation liable would result in an injustice, and therefore the trial court concluded that Ogbebor formed Stafford to further his scheme to commit insurance fraud, and accordingly the trial court allowed Cigna to pierce the corporate veil and hold Ogbebor liable for Stafford's conduct as well as its own. In addition, Cigna calculated damages based on payments for dialysis supposedly provided to one plan member for an amount totaling $763,592.27, plus payment for medication for the same member totaling $4,017,025.89. Cigna sought an additional $9,843 for payments based on purported ESRD treatments, both dialysis and medication, to a second plan member. These figures were corroborated by a detailed spreadsheet Cigna submitted along with the complaint, and they total $4,790,461.65. The trial court awarded that amount in actual damages, and further, because Cigna adequately stated a claim for civil theft under Connecticut statutes, the court applied treble damages for a total of $14,371,384.95. Judgment was entered against Mike Ogbebor and Stafford Renal, LLC, in the joint and several amount of $14,371,384.95, as well as a declaratory judgment that the plaintiffs are absolved of all and any liability to pay past or future claims submitted by Stafford Renal, LLC. In my opinion, although Cigna will have a difficult time collecting on this judgment, its actions and those of the district court should act as a deterrent to others attempting fraud, and they should advertise the fact of the judgment vigorously across the United States. If Ogbebor has any of the money he obtained by fraud, Cigna must aggressively seek to enforce the judgment and obtain any assets the fraudster still has. Other insurers should follow Cigna's lead and work to take the profit out of insurance fraud, collecting on these judgments, making Ogbebor and his corporation into an evil entity that must pay up is important to the fight against insurance fraud. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on zelma.com/blog, and if you subscribe, you will be given notice of every blog posting and every video. Please also consider subscribing to my YouTube channel, my Rumble channel, my Substack publications, and my locals community. If you found this video to be useful or interesting, please tell your friends and colleagues so that they can also subscribe and also enjoy the blog postings and videos. Thank you for your attention.